Hello everybody, my name is Prakriti. You all know me. Welcome to the Purple Corner, our little corner of JLF 2024. Today we have with us Aparna Chandra and Sital Kalantry, sorry about that, who've written Court on Trial, a data-driven history account of the Supreme Court of India. I kept thinking history. I'm going to dive straight in because we always have very little time at these interviews. And we're going to pass on mic, but there's no particular order. Either of you can take either question that I have. One is, of course, what inspired you? You mentioned earlier in the chat before we started recording that one of the things you thought about was this is known. We just want to find the proof of it, proof that it exists. We want to kind of, validate discussions and things that we know about the Supreme Court, but to put it in a book, one, and then to have a 10-year research period, which even for it's even beyond PhDs. So that kind of sustaining the freshness of outlook and keeping up with what I presume would be a lot of developments along the way. So these are two questions. One on just the idea of bringing the book out and the paperback and the trade paperback format, or hardback in this case, but in the trade publication format with Penguin, and then the research process. Two things that I want to start off with.
So the Supreme Court of India is one of the most important courts in the world in terms of jurisdiction. 20% of the world's people are under its jurisdiction. Yet nobody has undertaken the kind of study that we have undertaken. This field is called empirical legal studies in the United States, and the law school where I was at was one of the places where it was founded. And so we're studying, there's court studies like this, of course, around the world, and so we wanted to figure out what is the court doing, right? And it's also important in India. Whenever I come to India, I open the paper and I see Indian Supreme Court, page 1, page 2, Indian Supreme Court. So given that, I feel also that the Indian population doesn't really know how many judges does it have, how does it appoint itself, how many PILs is it doing, just basic questions of functioning. Even though people know about individual cases, they don't know that, well, that the individual case was decided this way possibly because the Chief Justice of India appointed a bench in a certain way. Those are questions that we wanted to ask, and we found out a trove of information through our wonderful co-authors that we published in this book.
And just to say something about the format of publication, it was a very intentional choice to go with the trade publication. So we have backing this book, the data that we present here, we've written a bunch of academic articles on it, but when it came to writing a book, one impulse that we had was to take this to the general public, right? These are like you were mentioning in our conversation preceding the interview, we were discussing that some of what we present are things that are spoken about on the inside, right? But these are anecdotal things. Oh, there's this one case where the judge said this happened, that happened. It's anecdotal, it's one-off, etc. So there's no evidence for it. But the second thing is, while insiders might know, the public, which is the biggest stakeholder, doesn't, right? So the idea behind going to Penguin and publishing with a trade publisher was pretty much, and in this accessible style, was pretty much to make sure that this becomes part of a general conversation, so more of a citizen-focused conversation. And so if you look at our ultimate solutions as well to the problems we highlight, it's about how do we make the court more transparent and more accountable, and accountable to either or but also to the public, by having transparent standards, transparent processes, which the public can look at and say, okay, we can judge fairly, we can judge back, right? Judge back the court and say whether the court is performing its role.
I have 50 million questions, but I will not have time to answer and ask them all. You mentioned one, a consolidation, and second, a public-facing one. Legal language. I only recently could get through a legal document. I have one of, although I'm a reader and fine print doesn't matter to me, a small text font doesn't matter to me, but there is something about legal language that a lay reader takes time to get through. And you're both academics, written academic papers, which I assume would have far more legal jargon. It would be in very different sophisticated style, legal language speaking. So one, were there challenges in making it very accessible to the lay reader? Second, you spoke of public transparency, the court being transparent to the public. Um, and this is a little tangential, but I studied journalism, and the first time I picked up a Indian Penal Code book was during my years as a journalist, because my professor said, as a journalist, you should know what sections are there, what crime falls under which section, and that for me felt like an unlocked part of being a citizen, because I didn't know. And I feel like this book, I have not yet had a chance to read. I'm lucky because JLF brought me introduced me to this book. But I'm looking forward to it for the same reason. I feel like it's going to unlock a part of my being a citizen in the country. So, do you think that this exercise of the court being transparent to the public also has to be by educating the public more and more nuanced? Yeah, that's the kind of long.
So, one I should say personally for me, writing for a general audience was a challenge, because my entire training is to write for either judges as a lawyer, or to write for other academics as an academic, and those styles are very different. Since you mentioned but this was a conscious. I am definitely the I think that I've carried forward the learning of writing in this style also to my more academic papers. But I should say, since you mentioned the Indian Penal Code, and as we know, decolonizing the Indian criminal system is the flavor of this season. I'm putting it in quotes. One thing that we are faced with in this country is a very colonial and arcane legal language, right? Which is completely disconnected from the everyday lives of people who are impacted by the law. And so simplifying legal language is something that we attempt in law schools. I don't think we've done that very successfully. Unfortunately, our law students are introduced very quickly to legal jargon, and that's sort of held out as the thing, as the way to write. So we have to constantly battle against that style. But you're absolutely right that unless we can simplify legal language, legal awareness about our rights, awareness about how our institutions function, because judgments are not the only thing. Like you mentioned, the Indian Penal Code. Now your Bharat Nyaya Sanhita and whatever else it's called, the new criminal code, it's also written in English in a pretty similar arcane style. How does a citizen make sense of what is it that the criminal code prohibits them from doing? What is it that it permits them from doing? And therefore, what is the range of their freedoms? What are the range of their unfreedoms? And therefore, how should they hold the government to account?
Absolutely. Do you want to answer? Okay, lovely. Language, we touched upon it, and I know you all have had a conversation about it earlier yesterday. One of the things is that such a minuscule percentage, maybe not minuscule, now everyone speaks English, but not everyone understands English inherently. A lot of our teaching in English is very conducive to rote learning. It encourages rote learning. It encourages you to learn English in a very functional, transactional way. And then you have something like understanding the values of democracy, the legal layer of it, the kind of social, cultural layers of it. So in terms of your book, have you thought about translating it? Have you thought about, like, what do you imagine are the different ways of, not just as a book in English that a lay reader can understand, but as something, as information that needs to be given to the Indian citizen? How do you imagine the widest possible reach for it? Have you all thought about that? And can you talk a little about it?
So we wrote this book in a very accessible way to an average person, not just an academic, not just a lawyer, but a journalist, anyone who is interested in learning about the functionings of the court, not about specific opinions, but the process, right? How many judges are they? How are they appointed? And we think it should be available in multiple languages in India, because not everybody speaks English, and not everyone speaks Hindi. So we hope for widespread dissemination. We think every law student should read this. It should be part of the core curriculum in law schools, because currently what law schools might teach is specific cases. And that's what I teach. I teach at an American law school, and my contract law class, we have a case book. All we are told to teach is teach them these cases. Within those cases in that conversation, I talk about the process, how courts work. But here we've laid it down in one book about the modern Supreme Court.
I will just say that I think there are vocabularies of democracy that are available in all languages, and there is this, democracy in India would survive if there wasn't a passionate attachment to it in the different languages. And so it might not speak the exact, people might not know what the Constitution says, but they know what democracy means, and they live that, right? And so Baba Sahib had said, democracy in India is a topsoil of a system that's inherently undemocratic. And in this context, he says, he talks about something called constitutional morality. He says it's precisely those values that you're talking about, that we need to, unless people actually believe in these values, the system of democracy is not going to survive. And to my mind, whatever else may have gone right or wrong with this country, that lay attachment to elections, for example, to the idea that the government should broadly be accountable to the people, and that as citizens, one is a right bearer. So in different languages, there is vocabulary about claiming and seeking and accountability, so on and so forth. So I would just say that even if it's not legal language and it's not awareness of that, the value system underlying much of a democratic processes is there and is available. When it courts, unfortunately, because court language is particularly, there's a mystique around courts, there is obfuscation around courts, etc., that it's difficult to sort of parse through what is it that courts are doing. The idea that courts should be accountable is also counterintuitive. Courts are the ones that hold people accountable. So, but what we are saying is that, well, you're exercising public power. You're exercising the most important sort of questions around life and death, on what government should be in power, what should not be in power, who gets the money in campaign finance, electoral bonds, so on and so forth. Of course you need to be accountable, right? For exercising public power, you need to be accountable. And that same level of sort of deepening of democracy that we've seen in our political system should also be something that holds the sort of courts to account. So with that in mind, we have conversations about whether it makes sense to translate this into different Indian languages. And we literally started having that conversation yesterday, so we don't know where that's going to go, but definitely the impulse is there to get the word out, so that, talking about the court becomes a central part of how we talk about a democratic system, just because the courts are so important to our democratic system.
And I think that's so important, because even though in theory and also in practice, but in, and I can only be anecdotal, I can only say from anecdotal experience, the everyday parlance is not the differentiation of law, judiciary, parliament, and what do you call it?
The executive.
The executive. So there is not, that distinction doesn't come in language. Yeah. It's there on paper. It's there as it's practiced. You see the Supreme Court often going against, fighting against the government on something, but you don't. It's not automatically assumed. So I really like what you said about the democracy, those values, and talking about holding the court accountable to those values as well. Last question, and I think most pertinent, is what do you think is the power of such a book and such a discussion, and to have a lot of people read it, to bring about that actual change? And what are the kind of constitutional, legal, processes, because it's a book about process? What is that process? How would it look like if, say, one of those suggestions also was, just pick any one example, if it were to be actually implemented for the better, what would that look like?
So, when you're making any policy recommendation, the first thing you have to look at is desirability, and then you look at feasibility, right? So, what we've done in this book is we've set out an ambitious set of desires about the court. Some of it is immediately feasible, right? It requires essentially the court to have the will. And Sital ended our conversation at the panel with saying that there's a need for will from within the institution to change. So some of it is a matter of will. Some of it is a matter of minor rule changes that are within the control of the court. Some of this requires Parliament to pass a law. Some of this requires constitutional amendment, which will require not just Parliament to pass a law, but half the states to ratify it. So there are different elements of it. We lay that out so that becomes part of the conversation. But essentially, ultimately, it boils down to a question of will. If there is a will in law, we've seen, in this last 75 years, last week marked 75th year of the establishment of the court. In these last 75 years, we've seen fundamental changes in how the court views itself and how it is viewed in the public. And so there's nothing to say that will, if the will is there, that it cannot find its own way. But yeah, many of these suggestions can be implemented tomorrow if the will is there.
So people have questioned the title of the book, Court on Trial. We had a launch on Sunday, and Justice Thakur said, who is putting the court on trial? And what I would like to say to that is, I think it's the Indian people that should put the court on trial. And this book was written in an accessible way so that the Indian people can educate themselves. Democracy can't function without an educated populace. And it is our hope that people either read this book, other books, other data, and inform themselves and ask this question: is the court living up to what it claims to be its core value? If its core value is public interest, constitutional cases, justice to the poor, standing up to the executive when it comes to certain cases, is it doing that? And our goal isn't those individual cases. Our goal is to say that if you look at this and look at the reforms, it's overwhelming itself with regular day-to-day appeals, so it has no time. But if it would take these reforms, then it could be more powerful. It could stand up to the government. It could answer those questions that the population needs. So it's, again, to summarize, we hope that this starts a critical conversation across India about what we want our court to be.
That was the last question, but I'm going to sneak in one more because you mentioned the education of the public, which we've been talking about in parts also through the conversation. Do either of you have recommendations of books that touch upon these aspects or that help you become a better citizen in as easily readable manner?
So let me just say one that comes immediately to mind is a book called A People's Constitution by Rohit Day. And I don't know if you've had a chance to highlight that book on your platform, but I would urge you to read it. It's also been translated into various Indian languages. But one thing that book does is to see how, there's one way to understand the Constitution, which is to say that the framers wrote the Constitution and the state implemented it and the judges interpreted it, so on and so forth. And what that book does is it says, well, how did the people make it their own? Why is it that this Constitution stuck? There's no reason why, it was an unheard of experiment at the time when the Constitution was framed. Framers were very concerned that, what is to say that tomorrow people will say, yes, we will govern ourselves according to this Constitution, but it stuck, right? And we're very much an exception in post-colonial societies in that it has broadly stuck, perhaps coming unstuck at the present moment, but broadly stuck in these over these 75 years. And just to say, so therefore this book does this job of saying, how did the people make this Constitution their own? And that's not coming from top down. That's coming from very bottoms up, sense of constitutionalism. So I would really recommend sort of getting that sense of engagement with the Constitution that the public can have without thinking of themselves necessarily as speaking the language of the law, but articulating questions of justice, injustice in constitutional terms, and that's how the constitution becomes Indian and becomes its own, becomes our own. So that's a book that I would definitely recommend.
Lovely. Would you add to that?
So, Fali Nariman has written a while ago a book, everyone knows who he is, called God Save the Court. And I think it critiques the court in many of the similar ways that we are. So the suggestions or the critiques we have are not necessarily extremely new ones. They're just data proven ones. So a lot of these opinions have been laid out in his book, have been whispered in the halls of the Supreme Court, but haven't been said in one place. So I think start with that as our core reading of the critique of the court is Fali Nariman's book.
Thank you so much. It was such an invigorating conversation, and thank you so much for taking the time out during the JLF.